Good day. My name is Shashitra Mariana from Palagendra. My registration number 06DK821F1155. My lecturer name Pon Aslina Binti Maswan. Today I like to present about the problem statement by referring standard form of contract PWD form 203 or 203A. The introduction of this topic is, in this era of globalization, not only in Malaysia, in all the country, we get used with COVID-19 virus, which can cause lockdown with the name of MCO to all the country people. In the season of MCO, a lot of companies and parties get impacted, especially for the people who are working in construction works, because of this MCO, the workers and also the contractor are given pressures to stop working and also to not continue working. To support, according to the Clause 43.0, extension of time is applied by the contractor because of the force majeure. Force majeure refers to a clause that is included in a contract to remove liability for natural and unavailable catastrophes that interrupt the expected course of events and prevent participants from fulfilling obligations. The contractor apply extension of time which stated in 43.0. It is happened because of MCO. According to clause of 44.0, loss and expenses is the term of often used, most notable in the JCT contracts, to describe the additional costs incurred by the contractor as a result of disturbance to regular progress of works caused by matters either within the employer's control or breach of contract by the employer. According to clause 43.0, if the progress of work delayed, the contractor shall forthwith give written notice to the SO as the cause of delay and some relevant information with supporting documents enabling the said officer to form an opinion as to the cause and calculation of the length of the delay. The contractor give the document to SO. It is because to inform the SO that the contract has been stopped because of the MCO. Next, according to the clause of 43.1, which is force majeure. The meaning of force majeure is an unexpected situation will occur which will cause a person from performing his responsibility as that enriched in the contract. Next is extension of time procedure. There is four. So number one is notice of delay. Most contract requires that a claim for an extension of time be made strictly in accordance with specific procedural requirements. While every contract prescribes its own procedure, certain processes tend to be common. A notice of delay and the intention to make a claim is usually required first. Following this a formal claim is usually required in accordance with the process that set out in the contract. The notice of the delay is generally a notice for the information only and is not a claim. Contract administrator need to be aware of distinction between a notice of delay and the making of a claim. Notice under a contract from one party to another advertising of a delay which has been caused to the obligants to the performance under the contract. Under a construction contract, there may be specific requirements for such a notice and specified consequences upon its issue. Then the number 2 is time bar. A time bar is a clause or condition which limits the time within which certain contractual rights can be enforced. A notice must be given under a contract in order for it to be effective in building up a contractual entitlement. Time bar occurs in construction contracts in different clauses for different purposes. For example, talent, conditions, extension of time, progress payments, and disputes. For example, in AS 4000 or AS 4902, the contractor is only entitled to extension of time claims if it submits a written claims within 28 days of when it shall reasonable have become aware of the cause of the delay. AS 4300 and AS 2124 contains a similar time bar, with the contractor being obliged to give a notice within 28 days after the delay occurs. Number 3 is contractor's failure to issue a notice for EOT. A failure to comply with the majority requirement to give notice within a prescribed period of time will result in the loss of the right to claim an EOT, which is extension of time. The underlying logic is that notice of delay and claims for EOT shall be given within such time as will allow the principal or its superintendent to take some remedial action while the events are still taking place. And number 4 is superintendent discretion to grant EOT, which is extension of time in the absence of notice. It has been suggested that the principal or superintendent may have been implied obliged to act in good faith and to extend time even if there has been a failure on the part of the contractor to issue a notice or make a claim for an EOT, which is extension of time. This has occurred because of the obligations expressed in some contracts that the contract administrator or superintendent act fairly, as well as having an express discretion to extend time for any reason. According to clause 44.5, which is loss and expense, it consists of any loss suffered or expense incurred as will arise naturally and in the ordinary course of things. It also can be considered as directly and naturally from the plaintiff's breach of contract. According to clause 44.1, if at any time during the regular progress of the works or any part of there has been materially affected by reason of delays as stated under clause 43.1, and the contractor has incurred direct loss and expenses beyond that reasonable contemplate, and for which the contractor will not be remunerated by a payment made under any other provision in this contract, then the contractor shall within 13 days of the occurrence of such event or circumstance give notice in writings to the SO of his intention to claim for such direct and expenses, together with an estimate of the time estimate of amount of such loss and expenses, subject always to be clause 44.2 hereof. According to clause 44.2, as soon as it practicable, but not later than 90 days after practical completion of the work, the contractor shall submit full particulars of all claims for direct and indirect loss and expenses under clause 44.1, together with all supporting documents, vouchers, explanations and calculations which may be necessary to enable the direct loss and expenses to be ascertained by the SO shall be added to the contract sum. Next, according to clause 44.3, if the contractor fails to comply with clause 44.1 and 44.2, we shall not be entitled to such claims and government shall be discharged from all liability in connection with the claims. Thank you.